Okay. We will call this meeting to order. We're running a little late. What we may have to do is that was a very important meeting that the committee just got through with. We may have to move that back behind the ENF so they can go 2 hours or 3 hours, because it is an important committee. And when you have a budget as large as what we do in the health department, I doubt if an hour and a half is sufficient enough, and that's what we did yesterday. But again, when you put Dr. Grimm on the stand and you're trying to get pointed questions, you better allow yourself 2 hours. So I would recommend, Shelley, just put that on the back side, and they can go an hour, 2 hours, and we can stay on time.
When we have our normal schedule, and they start at 11, they have until 1. But today, since we're doing back-to-back, they got cut short till 1 hour.
Okay. All right. Well, anyway, we'll start our Rules Committee meeting at, I'm going to say 10:30. So, Councilor Hargis, would you give the blessing?
Heavenly Father, we thank you for the opportunity to serve the Cherokee people. We thank you for all that you do for us, and we just ask you to guide and direct this meeting and to keep our minds clear of what's best for our Cherokee people. In Jesus' name we pray.
Roll call.
That's yours.
Honey.
Brian Warner.
Honey.
Bill England.
Honey.
Keith Austin.
Here.
Harley Bowser.
Here.
Sean Crittenden.
Here.
Mike Dobbins.
Here.
Frankie Hargis.
Present.
Wanda Hatfield. Rex Jordan.
Here.
Dick Lay.
Honey.
Mike Shambaugh.
Here.
Mary Bakershaw. E.O. Smith.
Here.
Janice Taylor. Here. Victoria Vasquez. David Walkenstick.
Honey.
So we do have a quorum. At this time, I'd entertain approval of the minutes.
So moved.
Got a motion and a second. All in favor signify by saying aye.
Aye.
All opposed, the ayes have it. Reports, Marshal Shannon Buell.
Good morning. Besides the report in front of you, I really have nothing to add, and definitely take questions if you have it.
Yes, Councilor Walkenstick.
I just want to know what the status is of the BIA comparability and our marshals on their pay scale.
It's still continuing. I checked with the Attorney General's office this morning, and they're about completed with their part of it, so it's moving forward.
Okay, so in November and next month's meeting, will you guys have something in concrete?
I don't want to say, once it got out of my hands, it's in other departments' hands, so.
Chrissy, what's the status on that, Chrissy?
We're working on it. We're working with HR and finance. I mean, it's a process of actually checking numbers and making comparisons, and it's ongoing. We have to get different information from different departments, and I can't give you a concrete, but we are working on it.
Like, do you think it's going to be 6 months or a year?
I don't think so. I mean, I would like to say that we would be done next month, but I just can't.
I got you. Okay,
But
thank
we
you.
are working on it.
All right. Thank you, Chair.
Is an attempt to upgrade the pay scale, is that what you're proposing here, or
It's
just do an assessment of
Well,
comparing?
it's not my proposal. It's a federal law that if we receive BIA funds, that we have to pay BIA pay scale for our tribal police. So, I think 6 years ago, the Marshal Service gave the marshals pay that was adequate to the BIA pay scale, and they haven't received any advances in pay. So the BIA, they keep going here, and we've stayed right here. And so that's what I'm proposing.
How's the BIA funding? Does it continue to go up?
I could not even, you mean the funding we get from the BIA?
Yes, I mean the BIA, the Bureau of Indian Affairs, does their funding to the tribe, is it continue? He said the past 5 or 6 years, we kept going down, they kept going up. How's the funding been going?
Right. No, the funding is, to my knowledge, has stayed the same for law enforcement, for DOI, so.
Okay, so we need to ask the BIA for an increase in funding?
I would love to ask the BIA for more funding.
Well, I mean, it sounds like it's a compliance issue. Is
Right.
that not correct?
Yes, and that's what we're looking at.
Okay.
So Once we get all of what we're looking at completed, then we can see where we need to go for that.
Okay. And we're doing that assessment now?
Yes, we are.
Okay. All right, any more questions for our Marcia? Okay, good report.
Thank you.
Okay, Office of Attorney General, Chrissy Nemo.
First announcement is that the Murphy case has been scheduled for oral argument before the U.S. Supreme Court on November 27th. I am unsure at this time whether or not anyone will be attending that. You can, I believe they release audio of the oral argument same day, and then the transcript actually usually comes out within a couple of days. They don't live stream it, so you can't listen to it as it's happening, but very soon after it takes place, you can hear that. We probably won't get a decision on that case until next spring. We will have one before their June recess next year, but it's an important case, and I think they'll take their time on it, so we may be looking at May or June next year before we get a decision on that. A little bit of the update, just because we got a lot of inquiry about it. Counselor Smith and I went to Vian Public Schools on Indigenous Peoples Day and advocated for them to change their student handbook to allow a student to wear an eagle feather at graduation. There hasn't been any movement on that yet, but we think that maybe there will be. And several of the questions are, why did we get involved this time? We get these questions every year, and from the AG's perspective, people are usually asking us to sue someone. And that's not really a route to take on this. We don't necessarily, as the tribe, have any type of standing to file a suit against a public school because they won't allow a student to do something. But this was really a grassroots. We had a mom, she actually reached out to us last year because she had a son that graduated last year. She had a daughter that's going to be a senior this year. And her son did not get to wear his, and she wanted to get an early start this year to see if she could make something happen so her daughter could wear her feather. And so this was really a parent being an advocate, reaching out to our office, reaching out to her tribal council person, and the nation provided a letter signed by Secretary, and Counselor Smith and I both spoke at the school board meeting. So you all may get some requests from some of your constituents that we do that type of advocating with their schools as well, and we would be happy to help coordinate that. So
Would you send that letter
I will.
to, and
Yep.
so we could
get
disseminate
it to
it?
Gail, and she
Council
can
members.
get it out. And I want to talk about this ICWA case. I know we're running a little bit behind today, but what I would like to do with the chair's permission is do a real quick overview of the Indian Child Welfare Act. I do this every couple of years, and I know we have new folks, and there are always questions even about what ICWA is or is not, but then talk about the case. So really quickly, federal law passed in 1978. Some of the background on ICWA is that there were tribal communities that literally didn't have children in them. The Indian Child Welfare Act also started by activists, and it was grandmas in Indian communities realizing that their children were gone. There was lots of research done. There were multiple congressional testimony before Congress in 76 and 77. Some of the numbers that came out of that is, at the time in 1978 when ICWA was passed, that 1/3 of all Indian children were outside of their own home. And of those, roughly 85% were in non-Indian homes. So there was this systematic removal of Indian kids being placed in non-family, non-Indian homes. And tribes realized that if something wasn't done about it, that some of them would cease to exist. I always say I think it was the most important federal Indian law that we have, because everything else that we talk about in regards to tribes, sovereignty, land, resources, none of that matters if you don't have people, if you don't have tribal citizens. And there were literally tribes that were on the verge of extinction if the children were going to be continued to be removed out of their tribes. So it was a grassroots effort to approach Congress to get something done to stop this. And I know you all know the history, but it was boarding schools, it was state child welfare agencies, and it was also private institutions, many of them related with churches that were funding private adoption projects in Indian country. So we had this just mass removal of Indian children, and ICWA was passed in response to that 40 years ago. ICWA does not apply when two biological parents are getting a divorce and they're fighting over custody. We get that call once a week. Someone says, I'm Cherokee, my spouse is not, I want you to help me get custody of my kid. ICWA does not apply in that case. It applies when a child is being placed in the home of someone other than a biological parent, whether that be the state removing the child, a private guardianship, a private adoption. When it's in state court and a kid is not with their parent, that's when the protections of ICWA apply. ICWA applies to Indian children. By law, that definition is someone who is a member of a tribe or who is a biological child of a member and eligible for membership. And that part is really important because children are often removed at birth, whether forcible removal by a state DHS or placed for private adoption. And when a child is 4 hours old, there's no way to document that they are a citizen of the Cherokee Nation, so that eligibility portion kicks in. But it has to be both that they're eligible and that their parent is a member, so there's still the political connection through their parent being enrolled. Really quickly, what ICWA does, first of all, it raises the proof level that you need to remove a child from a home. If it's a temporary removal, there has to be clear and convincing evidence that continued custody with the parent would likely lead to serious harm to the child. If you're terminating parental rights and it's a permanent removal, there has to be evidence beyond a reasonable doubt that continued custody would lead to harm. Expert witness testimony is also required. It requires that if a children's not with their parent, that they are first placed with a family member, and that is a non-Indian or an Indian family member. And that's one that comes up a lot as well. So a non-Indian grandmother of an Indian child has the same right to have that child placed in her home as the Indian grandmother does, because ICWA is first about preserving family, second about preserving tribes. If they cannot be placed in a family home, they should be placed in their tribal member's home. So you have a Cherokee kid, you don't have a placement, you seek to place them in a Cherokee home. And if their tribe is not available, you seek to place them in some other tribal home.
Does that apply to state-recognized tribes?
No. ICWA only applies to federally recognized tribes and Alaskan Natives.
Okay.
It's a good question. We get that one often. And then the other really kind of important provision when we're talking about child welfare cases is the effort to prevent the breakup of the family or reunite the family. Under federal, non-ICWA, and state law, when DHS takes a child out of a home, they have to provide reasonable efforts to the parent to reunite that family. And what that really means most of the time is they get handed a list of things to do and are told to go do this. Go take this drug or mental health assessment. Go take these parenting classes. Go take these anger management classes. When an Indian child is involved under ICWA, they have to provide active efforts. There's case law and regulations about what that means, but it's more than just handing a parent a list of things that they have to fix. It is active engagement from state social services in helping them get those. So if there's an allegation of drug use and they have to take a drug and alcohol assessment, it's not just take it, it is here's the place that can do it. I can help you schedule an appointment. I can help you get transportation if you need it. If it's something that's out of pocket and you can't pay for it, the department can cover it. So those efforts to actively participate in family reunification, because that's what's supposed to happen when DHS takes a kid into custody. We're supposed to help parents, get things together and get the kid back in their home. There's also some provisions for private adoptions, including that parents can't consent until the child is 10 days old. Outside of ICWA, in some states, it's simply that the child be born. And we had a case one time where they didn't apply ICWA, although they should have. And we had a 15-year-old mother who less than 12 hours ago had given birth and also told the court that she wasn't on some medication that she was supposed to be taking for some alleged mental health issues, and they allowed her to consent to adoption. It requires that they come into court and do that before a judge. Some state laws allow birth parents to simply sign something outside of the presence of the court to place their child for adoption, and these are assurances that go back to the issue of there were very coercive practices going on by private adoption agencies to place children for adoption, and these were safeguards put in place to make sure that when Indian children were being placed for adoption, that their parents had the legal protection needed to make those decisions. So that's the kind of the background and the major points of what ICWA does. There's some more of it, but I think those are probably the most important. So now I want to talk about, and a little bit about that during the Veronica case, we had lots of support outside of Indian country in support of the Indian
Before you
Child
go to
Welfare Act.
Veronica case, this was a judge out of Texas,
Right.
correct?
Right.
So what is the next step for us?
So this case, this judge said that the Indian Child Welfare Act, specifically the part that allowed it to apply to those children who were eligible and the child of a member but not enrolled, he said that that was unconstitutional because it was based on race. And we have a long line of case law that says Indian law is not race-based because it's based on tribal sovereignty, political membership in a tribe, tribal affiliation. This is the first time that a federal court has ever found that any federal Indian law is race-based legislation. And so it's a really, really big deal. It's an ICWA case, but it's much broader than ICWA because it's federal Indian law. Title 25 of the U.S. Code is where all of Indian law is located. And if ICWA can be found to be race-based, so can Indian gaming, land into trust, protection of resources, all of those. And these arguments have been made. I mean, people have made these arguments in gaming cases where big money is involved in the past, but this is the first time that a court has agreed with that. And so this is a wake-up call to Indian country that we're all advocates of ICWA and we care about ICWA, and this is very, very important. But it's even bigger than that in this case. And what we will see if this argument is not overturned is this same race-based argument being used to attack other areas of federal Indian law, funding for tribes, that you shouldn't give tribes a special funding because it's based on their race, not on their political status. That decision was out of the Northern District in Texas. We have filed, I believe it was last Wednesday, we filed for an emergency stay asking the district court judge that issued the opinion to stay it, meaning it doesn't take effect. The other parties in that case, and it was 3 states and 3 private foster care placements that were all the plaintiffs in that case. The states are Texas, Louisiana, and Indiana. And they've responded. Their responses were filed yesterday, so we expect a pretty quick decision from that judge on whether or not the decision will be stayed.
There are not very many recognized tribes in those 3 states.
There aren't. And, I think that may have been part of the strategic plan of the states that joined. States that have large Native populations hear from their Native constituents saying, we don't want you to support this because ICWA is important to us. So you have these states that don't have a lot. They don't have a lot to lose as far as state lawmakers, state attorney generals, because they don't have that population in their state. We do expect a decision soon on this stay. If it's not granted, we're appealing this case either way. If we don't grant the stay, we have to appeal it quicker than we would if we get the stay. But it will go to the 5th Circuit. And a lot of people comment, well, they don't know anything about Indian law. They don't have very many Indian law cases. But the 5th Circuit is where the Mississippi Choctaws won the Dollar General case. So their most recent Indian law decision was a really good Indian law decision. So we also think that the decision out of the district court is a bad decision. So we are hopeful that on appeal that we will prevail. If we win at the 5th Circuit, I think that the other side will attempt to go to the Supreme Court with this. But it doesn't create any split in authority because this is the first court that's found this. If we win on appeal, there aren't any other circuit courts that have the same opinion. If we lose on appeal, it elevates this case to the likelihood that the Supreme Court would take it because you would have a 5th Circuit decision saying, yes, this law is race-based, and you have all of the other courts saying, no, it's not, and those are often the cases that the Supreme Court takes. So it's a risk to appeal this case, but it's a risk that we have to take because, again, if this thing spreads, it spreads not just through Cherokee Nation or not just through Oklahoma, through all of Indian country, and it affects all of Indian country. This is, when I talk about ICWA, it is the one area that tribes are united on. When you talk about issues like land into trust or drilling in Indian country, there are tribes that have very, very different opinions about those types of things. But this is the one area that we see, across Indian country, that there is unified support for the Indian Child Welfare Act. So this will be a really big deal. And
It's first item on the agenda at NCAI this coming week.
And part of what was really frustrating about yesterday, I'm not going to talk about politics specifically, but we had someone who, we expect to be an ally in Indian country make claims about their Cherokee or Indian identity, and we're trying to focus a conversation on the Indian Child Welfare Act and what that means, and we now have kind of both sides of this argument being used against tribes. We have a court saying, well, they're Indian because because it's based on race, and it's not enough to have a political affiliation. And then you have the other side of the spectrum saying, I have Indian blood, so I can be an Indian. And it really sidetracks a very, very important conversation about tribal membership and who gets to determine that, and why it's important, and why Indian law is based on tribal membership versus heritage or claims to citizenship. So. Especially in the ICWA circle, yesterday there were lots of frustrated people saying this is the same issue that this judge used to tell us that we can't protect our Indian children anymore, and it's been overtaken by political talk about it. So it's frustrating from an advocate level trying to protect the Indian Child Welfare Act and take care of Indian kids. That's where we're at.
I have a question.
Counselor
Sambo.
I'm sorry. Is this the DNA deal you're talking about?
Yes.
I pulled up Google last night to check the news, and the first article at Secretary of State said Cherokee Nation. So that's kind of neat. You were on Google last night, and it was about the Warren DNA deal. So that's all I had.
Anybody else? Yes, Counselor Taylor.
Can you briefly
No.
explain? Yeah, that's why I led with that, Chrissy. Standing to sue in this ICWA case. It is my understanding that the Burkines filed suit after they had already adopted this child, so they were not harmed.
Right. That is one of the there's 3 families in 3 states, and it is the case that started this. They were in state court. They appealed in state court. Then they filed the federal court in the federal case in Texas. They have finalized the adoption of the Cherokee Navajo child that's in their home, yet they're still pursuing this. There are issues as to whether or not they still have standing, but even if they don't, the other foster parents involved and the states, to the extent that the court found that they had standing, can still pursue it.
Explain to me how a state is harmed when
So
the ICWA law is applied. I don't
part
get
of
that.
the argument, and it's another part of the decision that is concerning, but not as much as a race-based issue. The 3 states said, first of all, I'm going to get a little legal, but try not to. The 10th Amendment says that if the Constitution doesn't give certain powers to the federal government, that they're reserved to the state. And one of those traditional state powers are family law issues, the creation of marriage, divorce, custody. Those are state court issues. ICWA is a federal law that state courts have to apply in state court to state court issues. And the argument from the state level is these should be state powers. Federal government shouldn't be able to tell us what to do in custody cases in state court. And they're exceeding their authority under the Constitution. Congress is exceeding their authority under the Constitution to require state courts to apply this rule in state court proceedings, and the judge agreed with them on that as well. The states also claim that it's a unfunded mandate. Basically, it costs them money to comply with this, and they don't get funding for that from the government. So those are the arguments from the state perspective
about how they are harmed by having to follow the Indian Child Welfare Act.
All right, that was actually pretty good, Chrissy.
And I will keep you all updated as we get decisions or movement on this case. When we get a decision on the stay, when we actually file the appeal, I'll send that to Speaker and Gail to distribute. But just know that this case is a really, really big deal, and you know, we also may be asking you for some money at some point. This is these cases cost a lot of money, but whatever it is, it's worth it, and we have to do it. We can't let this one go.
And Supreme Court, usually they do not weigh in on an Indian issue unless we've had a favorable ruling in the lower courts.
Unfortunately.
Then they usually weigh in.
Yeah,
If it's a favorable ruling, they usually like to touch it.
Yeah, they take the cases that we win, unfortunately.
So, but we have to play it out. Anybody else? Councilor Watkins.
Thank you, Speaker. I read a little bit of the situation they were buying in with the eagle feather, and I know that this young man that they're referring to, him and his family, they're stomp grounds people, and that's their religion, is wearing that feather, and so, you know, I guess, you know, being a school official, you know, we got sued for millions of dollars one time because this one young lady, I forgot which religion it was, but it was something that she had to wear a garment on her head, and we had a no hat policy in the school district. And anyways, the young lady and her family schooled the district for a lot of money, and they were successful. And so, ever since then, the school board changed their ways as far as for religious practices. They could wear whatever regalia they wanted to wear. And going back to this young man in the eagle feather, you know, that's his religious practice. Now, with a cultural Native American that it's not his religion, and he wants to wear a feather at graduation, you know, there's board policies in place, but I think with this situation, I think that there could be a lawsuit of some sorts to defend this young man. But for rest of our Native American population that would wish to wear an eagle feather, I don't know if they got much ground to stand on legally. You know.
So I think you're right. I mean, I think even under state law, Oklahoma has a very strict religious freedoms law that the individuals, that this young man and his family may have some legal recourse. It's just that the nation doesn't necessarily have the ability to sue the school. And we did not ask the school to take a specific action. We kind of gave them some options. We said, hey, look, first of all, you can let kids wear whatever they want at graduation. If you don't want to do that, you can make religious exceptions, or you can make other exceptions if they request it in writing and let you see it beforehand so you can approve it or deny it. So we didn't ask them specifically to grant or not a religious exception, because then you get into issues of proving that that is a I can't remember the word, it's not honestly held, but a truly held religious belief in order to be granted a religious exception. So you get into what is religious and what is not. So we didn't address specifically how they should do it. We asked them to look at their policy and reconsider, because what happened was over the summer, the school put in their handbook, there was nothing in there last year, didn't say anything about graduation hats, caps, and gowns. Over the summer, they put in 3 sentences that said caps and gowns could not be altered or adorned in any way, and the only thing that could be worn was what was provided by the school. So in this situation, we were simply asking them to kind of rethink that policy and look at different ways that they could allow it. So I agree that there are some differences there, but we weren't advocating anything specific, and there very well may be legal action. There was a case 2 years ago, I think it was out of Caney, but someone may remember, a young woman, where is it? Ramona. She filed a federal district court case, and she lost because the court said that it was a statute of general applicability, and they didn't rule on the Oklahoma part of the law. They just ruled on it under federal law. So the ability to win that case under federal law has kind of been decided in this area, but there may be some state law claims. But again, this was not one, the family wasn't asking us to sue. They were just saying, can you guys support us and back us up and provide us some information and be there, and we did. And, you know, so I think it was maybe a little bit of the honey approach, not entirely, but it was more, we want to provide you information and we want you to hear us out, instead of, I did mention to them how much money Cherokee Nation gives to Bryan Public Schools and Sequoia County every year, just to remind them, but I didn't threaten that it wasn't going to be there. So it was more of a, we want you to hear us out, we want you to, you know, give you the right thing, or give you the chance, school, to do the right thing on this. So we hope they do.
Gotcha. You know,
Go ahead.
oh, now, you know, the Elizabeth Warren thing, that's, I think it's irrelevant. You know, 30 years ago, nobody was Indian. Nobody wanted to be Indian. Now,
Wait a minute now.
but now everyone wants to be Indian. I mean, you can walk down Main Street in Tahlequah, Oklahoma, and everyone has a story about, you know, their grandma was an Indian princess or something along those lines. And so, you know, as the elder said last night in tribal council, it's a good day to be an Indian. You know, a lot of people want to be Indian. And so, you know, this Warren lady, you know, the DNA test and all that. I mean, go back to the Dawes Rose. You know, it's a flawed system. The Dawes Rose were dog tags that they put on our Indian people to give out land. And, you know, there was non-Indian people that was on the Dawes Rose. But go back further to the Dawes Rose, our Cherokee tribes. To be a member of a Cherokee tribe, you'd live within the jurisdiction for 6 months, and you were a tribal member, Indian or non-Indian, black, white, Mexican, whatever. So defining what an Indian is has always been a question in the federal law, and but you know, we have our own laws here in the Cherokee Nation. You know, being an ancestor of the Dawes Rose, and we have our own Cherokee rules and laws. But for this lady to say, you know, she thinks she's Indian or she's Indian and make national attention, and you know, I just, you know, I run across thousands of people that think they're Indian every day. When I was the Indian Ed director at Muskogee, that was a common thing, but I didn't get offended that they thought they were Indian. Who cares? You know, if someone wants to be an Indian, you have an ally, especially up in the national level. I mean, that's but anyways.
I care, especially, like I said, when it comes to this ICWA issue. It's such a, because people, we all get it, right? But people outside of Indian country don't.
There's a non-Indian that comes up to you and says, hey, I think I'm Indian. You get offended over that person thinking they're Indian.
Do I get offended?
Well,
No, I ask them questions. I ask them if they're a member of a tribe or, but the conversation, the reason it's problematic is because we have this law that is, you know, the headline is that Indian children are harmed by federal law, which is crap, basically. But you have people outside of our communities don't know what it takes to be a member of a tribe. And like you said, I hear every day, I mean, there's not a day goes by that I don't talk to some stranger that they find out I work for Cherokee Nation, or because I am blonde and they know I'm Cherokee, they want to tell me about their ancestors and their you know, history and everything else. But it confuses a conversation, especially on legal issues, when it comes to, you know, the law and how tribes are dealt with on a government-to-government basis, and people don't understand that. On the other side of the fence, Lindsey Graham said this morning, well, he's going to take a DNA test, and if he's Indian, he wants a casino. And that's harmful to us, right? Because people don't even understand why tribes have casinos. They think it's just some special privilege, not that we have sovereignty on our land and the state can't tell us what to do with it, not because someone granted that to us, but because we have it. So I think that why it's problematic is it takes away from real conversations and real issues about what's going on in Indian country, and it makes a joke out of it. On both sides, I think it makes a joke out of it, and it's not a joke to us. And you know, this is going to be an ongoing thing. People are going to be, you know, whether it's comedians or politicians or actors, singers, people are going to be taking DNA tests and saying they're Cherokee, and
It's a joke.
you know, in the meantime, we are at risk of not being able to be involved in cases when kids are taken out of their homes and not being able to help them because of this conversation.
The bottom line is that we're a sovereign tribe, and we determine our own citizenship, which, you know, that was the whole fight through the Freedman case. You know, our people voted on the Constitution. They wanted a Cherokee by blood tribe, and it was their ability to exercise that through democracy and voting, and determine their own citizenship. So, you know, at the end of the day, regardless of what people say, our Cherokee law stands. We're a Cherokee by blood tribe. So, anyway, I just thought it was ridiculous, all the media attention it's getting. That's all. Thank you, Speaker.
I think the bigger issue is that we don't want people who aren't Cherokee, who simply claim to be Cherokee, speaking for us. If we're going to be talking about Cherokee issues, we want Cherokees to be the ones who are talking about it.
I agree.
Anybody else?
Follow up.
Yes.
Councilor Smith.
Oh, just real quick on the feather thing. The administration and the school board gonna work with us and we're gonna get that resolved. They just didn't understand that this boy shows up every third Saturday and they do all the volunteer work and all that, but if she hadn't been there, it wouldn't have went that way, so she did a great job, but we're gonna get it all worked out.
Thank you.
Anybody else? Councilor Hatfield.
Could you come to more schools? Because we have the same issue. It's been going on for 3 or 4 years. And,
I think,
school board.
and what we'll go anywhere, but what we need
probably
to
need
do
to check
is
and
some
see
back
who's-
building.
Well, what you probably need to do, more schools, remember, it's not in our jurisdiction. You probably have Chickasaws that have students, more Chickasaws that go there, but you can present the same case.
But we need to do it the way we did this, where it starts with some parent involvement and conversations and letters, not just show up and say, we want to do this. But we can provide that information, and, you know, on this, we pulled up the school board policy. When they have a meeting, how do you get on the agenda? How do you talk to them? So we can do that, but we've got to start kind of from behind there.
14 county area, do you have much of a problem with that? I mean, we have superintendent's meeting, I know, administration meeting. I mean, are those topics discussed as far as regalia or, you know, cap and
Going to be
gowns?
now.
Yeah, well, they always have been.
And
They
I
were
think
discussed when my kids were at Tahlequah High School. I had 2 in Tahlequah High School, had 1 at Sequoia.
Well, even
We
this
didn't have any
one,
problems.
there was a student there that night from Vian who graduated, I think, in 2011, and she had a picture. She wore hers. So 7 years ago, it wasn't an issue. And I think a lot of it depends on administration at a school. You get a new principal or a new superintendent, and if it's just 1 or 2 kids, a lot of times they will make the exception, and it happens, and no one makes a big deal about it, and no one knows anything about it. But
Mine wore hers at Tahlequah High School.
yeah, just did it, right? Nobody didn't ask
well,
permission. Nobody said anything.
Well, you don't put it on Facebook
Right.
and you don't brag about it.
Right.
You know, that's not, when you wear a ceremonial stuff, you don't allow photographers anyway. You just, you do it because that's your way of life. If you're on Facebook and you're going to do a press conference, it's probably not your way of life anyway.
Well, I think for this young man it is, and he was. It was interesting because his family, you could tell, they were not in this to cause a stink or
Yeah.
you know, to get attention or anything else. They really just wanted to get this changed, and they were a great group of folks, and
Okay.
glad we could help them.
Well, the ICWA thing, I may need a little write-up on how we're taking our stand, because that will be asked of me at NCAI, if you would, please. Okay. Anybody else? Good topics. Thank you. Okay, Gwen Terrapin.
Good morning.
Morning.
Gwen?
I think you guys confused us having this in the morning instead of in the afternoon. So far on FOIA, we've got 17 requests. 14 of those are FOIA, and 5 of those in the FOIA are outstanding at this time. And I've got 3 GRAs, and 1 of those is outstanding. And all of you should have received a copy of all of those requests along with those responses. And at this time, I was unable to update the website because there's some internal updates going on with it. So no one is actually able to access the AG website at this time.
Okay. Any questions for Gwen? Your report. Election Commission, Marcus Fears. Good morning.
The report that y'all have was sent out a little before the month ended, so I wanted to just give you guys some updated numbers. We processed 793 applications in September. I wanted to recognize the staff of the Election Commission for doing a great job of verifying, processing, and filing all of them in a timely manner. We're up to 70,636 registered voters, 40,245 in district, and 30,391 at large. So I'll answer any questions if you guys have any.
Any questions for Marcus at this time? I like your breakdown of your numbers here, the way you've got that by precinct. That's very helpful.
Thank you.
We're not guessing anymore. Thursday night, you guys aren't busy, community building?
Absolutely, we'll be there.
Okay, appreciate you. Anybody else? Yes, Councilor Crittenden.
Marcus, you can find these dates and everything probably anywhere, but will you send out just a little bulletin of last date to register to vote, absentee request, and just send out a simple little bullet?
We will. As soon as we get everything verified on what we're going to use as far as, the act being verified and approved, then I will update our website and then I'll send all the dates out to you guys.
Yeah, just a little bullet.
Absolutely.
Thank you.
Okay, anybody else? Good report.
Thank you.
Okay, Tax Commission, Sharon Swepston.
Morning.
Morning.
Hi, Sharon.
I believe you have my report. I'll try to address any questions that you might have on that. I will address, I know last month when I spoke to you all, there was a question about the Catoosa office, and I have a quote to expand and redo that and add another window there, and we have also opened the positions there. We're trying to get them hired. It's a really hard, and you wouldn't think it would be. You'd think that'd be the easiest one to fill, but it's not. We got our applicants, and she set up interviews, and we had one person show up for an interview. So it's a little difficult for some reason to get them hired up there, but we are working on it. I spoke with Nason, he's working with me, and we are going to advertise it a little further out in some different papers, and hopefully can get some applicants in for that position up there.
Good. Well, you're doing your part.
I'm trying.
Okay. Any questions for Sharon? Yes, Councilor Crittenden.
Sharon, has there ever been any talk about putting one in Stillwell?
No, because we have the one there in Salisaw. And what we try to do to cut our overhead down is we tried to put them within 30 miles where nobody would have to drive more than 30 miles. I mean, we can put little offices everywhere, but the overhead is pretty tremendous when you start working with T1 lines and things like that. And that's why we've tried to place them in those
Never
areas.
has been in the county. A lot of Native Americans down there.
There is.
A lot of Cherokees.
Mm-hmm. We've got several areas that we could go to. It's just a matter of if we want to do the cost, because it will cut down quite a bit on our, or will raise our costs quite a bit to put in those other offices. But that's something that can be discussed.
All right, I appreciate that. Thank you.
Anybody else? Okay, good job.
Thank you.
Self-governance, I don't see her here today unless Kanan's going to give the report. Okay, so we're good. Gaming Commission, I saw him in earlier.
He was here and he wanted me to tell you he apologizes, but there was an emergency that arose with Tonette and he had to take her to the emergency room and he said he was sorry.
Okay, we understand. Okay, Human Resources, Dr. Nason Morton.
Good morning.
Good morning.
My report has not changed much since last month. Still working on end of year stuff and have been in contact with Sharon with the tag agency just to deal with not only her current vacancies, but trying to make sure that we can, in the long run, grow her department to meet the needs. Are there any questions?
Questions for,
Comment.
yes, Councilor Taylor?
So we often complain in here about the time to fill on the different positions. However, as we as counselors are out in the community at different events that we have, we visit with the staff from the different departments. And one thing that stands out to me is They are fit very well for their jobs. Every one of them acts like there's nothing they would rather do than tell you what's going on in career services or tell you what's going on at the election commission or something like that. And it does take time to find the right fit for each department. And so while it does take longer than we might wish, you're getting the right people in the right jobs, and ultimately that's what you want to do. So that's my observation.
Yes, we try to get as many qualified to them, and the department goes through them, and the interview process, you try to find the best fit. And
so you're doing a good job with that. That's all I have.
Okay. Anybody else?
Where did she say the
Hatfield.
positions were open? Did she say there was a vacancy where? In Catoosa? Okay.
You said Catoosa.
it may be Catoosa.
Okay,
I think
that's
I
fine,
have.
thank you.
I can find out because I have
Got
kind
it.
of
It's
a couple
okay. I thought
advertising.
that's what you said, thank you.
Okay.
Bill said it was Catoosa.
Yeah, and she said at least she
Okay.
had one applicant.
In Catoosa.
Yeah.
And we may need to advertise again, so.
You know, because one is a tribal member doesn't mean you're qualified to work for the tribe.
That's true.
Because we have 366,000 members plus, so there's just enough room for so many people. Gotta get qualified. Okay, anybody else? All right, good report.
All right, thank you very much.
All right, that ends our reports. Drop down to old business. This is a resolution recommending requirements for Supreme Court justice appointments and requests for comment from the Cherokee Nation Judicial Branch. When we tabled that last month, we said we would table it for 30 days. Since we moved our committee meetings up, it has not been 30 days. So I will just postpone that till the next rules meeting. Someone give me a motion on that?
Motion to second.
Okay, got a motion and a second. All in favor, signify by saying aye.
Aye.
Opposed? Thank you very much. Next one is Counselor Lay.
Chief, we've had a chance to look over the replacement guidelines from CMB, and they have installed the promotions and the upgrade training on the policy guidelines, hiring policy guidelines. And of course, the only reason I brought it forward because the new policy only had the hiring preference in it, and that was the policy for about 2 months. But they've upgraded to pretty much close to what the old policy was. So I'd like to withdraw that.
Okay. Thank you, Counselor Lay. Okay, motion to withdraw. We don't think we need a second on that, do we? Okay, all right. Counselor Walkenstick, you're up.
Thanks.
New business.
This is the act relating to the amendment of Title 18 of the Corporations Code requiring the Tribal Council to approve all campaign contributions given by our Cherokee-owned corporation. Put that form of a motion.
Got a motion? Second?
Second.
Got a second? Any discussion? Yes, Counselor Vasquez.
Okay, we already have in our present system a process in place for us to be notified of political contributions by CMB. And I think this law, trying to make this a law would be the first time that the council has imposed legislative approval of a line level item from CMB, and that runs counter to separation of government and business. I oppose it.
Okay, anybody else? Discussion. Counselor Critton.
Dave, I'd ask if the counselor could kind of lay out some of the gist of this for everyone.
Yeah, I mean, this isn't a new act. This was brought back in, I believe it was, hey, Talina, what year was this introduced? This act? Was it back in 2010 or 2009?
It was 2005.
2005.
When it was first introduced.
And this is, okay, and it was a similar situation back in the former administration where the chief was given a lot of campaign contributions to different people, and it was affecting the dividend that went back to the services of Cherokee people. And we all have our opinions of the $750,000 that we just gave to our government officials. And, they're from, some are from California, and some was for the governor's race and so forth. And, we all have our opinions of if it's a lot of money or it's not a lot of money. The fact is looking to the future, that's already done, but moving forward, looking to the future, do we want history to repeat itself? Because this is the second time that it's been an issue of the tribal council, of administration giving too much funds to political campaigns. And so, anyways, like I said, this is, Secretary, you have something to say?
Well, I wanted to correct a misstatement, which is a very material misstatement, which is the idea that...
Secretary, wait a minute. Were you through?
Well, I thought he yielded to me, Mr. Speaker. I apologize.
I yielded to him.
Okay, so you're through?
I'm not through. He just got up.
Well, I would yield back just to correct a misstatement, which is the notion that Chief Baker, that CNB donated to different races, including California, apart from the governor races, which Chief Baker phoned each of you about, in accordance with the policy that's been in place by the CNB Board of Directors. Apart from those donations, the regular was the normal PAC process, so the statement made that donations out to California are somehow part of this is a misstatement. It is incorrect.
All right. Thank you, Secretary.
Because I wasn't aware of any donations. The PAC contributions came before us.
Oh, yeah, that's correct.
Yes.
Yeah, that's correct. Well, okay. I think as a whole, as all the contributions we're given politically as a whole, they're going to people outside of Oklahoma and so forth. But anyways, with CNB, says what this is specifically addressing. It's the $750,000. Again, it's already done. Damage is done. I'm just moving forward. I would hope. I mean, I'm not going to be on this council, but I would hope that in the future this body would have the ability to step in and have a say of how you're directing your dollars to your constituents. Because this is whatever comes at the end of the day at CNB, whatever revenue that they receive, it comes back in the form of a dividend back to the Cherokee Nation of 37% of whatever they clear over there. So if they're spending $1 million or $2 million or whatever is on political contributions in the future, that's going to affect your scholarships. It's going to affect your contract health. It's going to affect a lot of the services that your people depend on heavily. So anyways, like I said, I presented this last month to try to prohibit this from happening, but little did I know that they didn't even have to get approval from the CNB board, because I thought that was going to be the process. It was just something that they just spent directly and gave to these political parties. Now, granted, I know that we do have a gaming compact coming up, and we do have to protect our interest in the future in gaming in Oklahoma. But I reiterate here, the leverage of all this is from the Cherokee Nation. We have the ball's in our court. We have the power, and what I mean by that is our large employment rate of over 9,000 people in northeast Oklahoma. Our Class 2 and Class 3 games. Class 2 is zero tax dollars to the state of Oklahoma, and Class 3 is the dollars that we get taxed on and we pay the state of Oklahoma. If you guys remember the Katua casino that was up, it paid zero taxes to the state of Oklahoma because there was 100% Class 2. So we have some leveraging power on our end to, in other words, stick it to the state. And that's my little soapbox on the gaming compact. I just want to let you know we have power here at the Cherokee Nation. We have control. We have some leverage. So don't ever think that we just need to pay legislators a lot of money to protect our assets in our state. we have a little bit in the game as well. But anyways, with this act, Councilman Critton, and that's kind of the nuts and bolts of it. I will tell you, I see our Attorney General here. He's gonna come and tell you guys that we're, and as Councilman Vasquez mentioned, that we're violating a our Corporation Act, and they're going to say, well, all the loans and agreements we have with the BOK and all the different banks, whenever you get another entity come in that's going to have a little say in how their money's spent, it's going to affect those agreements. But I will say that CMB and those corporations, they were put in place to bring money in, not give money away. And so I would hope that this body would consider this piece of legislation seriously, and in other contributions, not only political, but other contributions. But for today, this only addresses political contributions, Speaker. So
Okay.
that's all I have to say.
Anybody else? Councilor Austin.
You know, we speak of the business as if it's a magic pool of money. It's not. This is a business decision. The process of donating these dollars to political campaigns is a business decision in order to enhance our ability to do business. And that's a reality in living in the world. The world, much of what we do is the decisions of these government officials, these people running for office, affects our ability to do business and bring money back to this nation in the form of dividend. And these are investments that are made in order to protect our position, protect our ability to hire, protect our ability to create jobs, protect our ability to bring monies back to our communities. So we always have to remember not to do things that would somehow limit our business's ability to do what we ask them to do. Second, just from a standpoint of doing business, you can't put certain types of limitations will restrict them from being able to do it just because of the timeline of things. If you were to look at the election timeline, the state of Oklahoma elections, June was the primary, August was the runoffs. If you had somebody run in June and you don't know the results of it, but by the time you went through the political process, you couldn't even make all the committee meetings and we couldn't get the schedule done before they would have the opportunity to actually make the donations before the next election cycle through the calendar at times. Business has to be more nimble than government. And we have laws to protect our interest in our business. We have a board of directors that set the policies. That board of directors is all Cherokee people. They're all Cherokee people that we are the folks who have the right to appoint them or reappoint them, in the process. So we do have a process there, and the process works, and our dividend that grows every single year proves our process works.
Okay, anybody else? Councilor Critton?
Yeah, Dave, I'll be supporting this today simply because it's the Cherokee people's money. And I've heard since I was a young kid that the council controls the purse strings. That was long before there was a bunch of initials. C&E, C&B, C&I, people elected us. Some of them are glad they did. Some of them are maybe not so glad they did. But they elected us to have our nose in a lot of things. And Dave didn't say he would vote no for this donation. All he's saying is the people put us here. Why shouldn't we have a say-so in it? So I'll be supporting things like that as long as I'm in this seat. Thank you.
Anybody else? Councilor Lay.
I'll be brief, Chief.
Okay. You're good.
Do my best here to be brief. I think I've seen a similar act to this that was back in the mid-2000s that was voted yes on by Bill Baker and Chuck Hoskin. It may have been senior, not junior, I'm not sure. But is that true? And
Yes, Secretary.
I'd like to have
If the gentleman will yield, my recollection of when that issue came up when I was on the council is when Cherokee Nation businesses and its management did not give any notice to the council of the Cherokee Nation, was not obliged under its own rules to give notice to the council, to give notice to the chief, and there were donations made that had zero notice except what you might read in the paper. At the time, that seemed not the best course of action, and so I don't know if that legislation was the one then, but I do recall addressing this issue. It was resolved to my satisfaction as a member of this body when Cherokee Nation businesses said, you know what, you all are correct. We ought to give the Council of the Cherokee Nation notice. We ought to give the Chief of the Cherokee Nation the respect of notice. We ought to act in a coordinated manner, although we shouldn't embed it in law, otherwise you erode the important distinction between the government of the Cherokee Nation and the businesses of the Cherokee Nation, which has been a hallmark of our success, at least in the last 8 years. So to the extent the councilman is referencing legislation that came up before, that's the important context in which I suggest you should understand that legislation. Thank you, Councilman.
Okay.
and thank you for that answer. And we do get notified, and it's essentially after the fact. I mean, it's we all got notified, and this funding was going over, and we all know why, you know. But does the business board approve this? Somebody here said they did not. I'm not certain if I understand that.
I was going to recommend, if they don't, they probably need to be consulted, the business board. I mean, that's what they're there for. They're kind of our other checks and balances that we have here. We confirm all the board members. I don't have a problem with that. And the chief does call me when we're going to make a contribution. That works well for me as well. And we have to ante up if we're going to stay in this game that we're in. Our sovereignty is constantly attacked. So we have our CEO here with us today. Were the CNB board members notified of, are they notified when we're making contributions?
Yes, sir. 3 of the board members were, which are on the executive
Okay.
And does the board vote?
No, according to policy, the board does not vote. We just notify them, get their permission,
And so that's by policy?
Yes.
CNB policy?
Yes.
Okay. Anybody else? Yes, Councilman Critter.
I'm just curious while we're talking about it, what if the board didn't give permission? So you kind of poll them, not really a vote?
Consult the chairman of the board. Get his direction.
So I just, there's been different things where the charitable contributions, it was drawn up, you know, so we'd have a vote when something come up. And, you know, I can notify you of anything, but that don't mean you have any say-so in what the outcome is. So, you know, I'd like something in the future. Don't look like it's going to happen in the near future, but something a little stronger than a notification. Like I said, I can notify you that I'm going to jump off this building, but that don't hold no water unless we can say we go to our people. If a big amount of money's coming, we go to our people. I'm just speaking for me. I go to them and say, hey, we got this coming down the pipe. You're the one who put me in this padded seat. What do you want me to do with this big amount of money that essentially belongs to you? Then I come with my yay or nay. Everybody comes with their yay or nay, and the people has had a say-so in big dollars. And that's where I'm at. Thank you.
Okay. Councilor Warner?
Yes, sir. Thank you, Mr. Chair. I think, you know, you're looking at, I've heard some good things, and you start looking at this, and we have to be careful that this is not divisive in nature of, you know, when you start looking at money and you start asking different things. I think what Speaker Byrd led into was, I think the business board here's what we're saying, and let them take a look at this and make sure that all their checks and balances are in check. And if we don't like that, then there's something that we can do. But we don't want to get into this gridlock between the government side and this business side. I think in the past we've seen different things, and I just don't want it to slow down progress for an individual area, because things in our areas come up where you've got, it's got to be like this, and there's been similar instances where money's been given, but we needed it then because there was another entity that was matching, plus another individual who was matching money. So if we wait and we've got this individual here, well, he takes his $100,000 and goes on down the road when he's not even Cherokee, but he was willing to come and give us $100,000 if we're going to pony to the table with him. And then another company coming in that's a grant foundation, and they come with theirs. So I know we're talking about political contributions, but this has been the overlying thing over this, and I think it's a careful line to teeter on when you're looking at progress. I do understand where Councilor Crittenden's coming from, and you visit with those folks, but I think the decisions that I made, I don't mind to walk up into anybody's living room and tell them why I made a decision or not, So, thank you.
Good.
One last.
Councilor Stembaugh.
Well, I see both sides. I haven't been here that long, but what I have seen since I've been here is that CMB's been very successful in what they've done. I see where the majority of our money comes from, and it's because they are successful and they do make good decisions. I think that the broader picture, like Speaker Byrd says, it does deal with things just outside, just not about the contributions. We're talking about our sovereignty. We're talking about different things that we have to do to protect our nation. And I think this is something that we need to do to protect our nation. It's bigger reaching than just a political contribution, the way I see it. So yes, I can see where it would be maybe a kind of a neat idea to have maybe our hands where we can say, yes, you can do this, or yes, you can't. But at some point in time, you do have to have a little bit of faith in the horse that got you there. And I see that our CNB has done good things with our money, and it has helped our nation in a very positive way. So I'm going to support this for that fact, because I think it is a little bigger than just an oversight of money. I think it is how we protect our sovereignty, and it is how we fund our nation. And I think these things are important, and this is something we have to do. I just think it is.
Anybody else? Councilor Crittenden?
Yeah. Now, in those times when time is of the essence, if this body and the folks don't get a say-so, whose ultimate say-so is it?
Repeat that again.
If time's of the essence and this body don't have time to convene, who makes those decisions that keep it under the time limit? Whose ultimate decision is it?
Well, if the chief has an issue, he will call council members, and usually we have time. Very seldom do we not have time, but we appropriate the money, and if it goes beyond the budget, then the chief will address it through the board and give it to CEO and come back to us and consult us. That's usually the way it's been working. Chief?
Okay.
Thanks, sir. I don't want to beat a dead horse, but every person at this table got a personal phone call from me laying out what the ask was and why it was a good business investment. 15 said absolutely yes. One said he wanted to think about it, and one says no. That was That was what this body believed. If 10 had said no, then it would not have taken place. The law says that they do it and let you know. That's not what we did. So each and every one of you got a phone call, and before it was done, totally open, totally transparent, totally everything. You know, we talk about spending, them spend $1 million, and it affects scholarships. Let me tell you something. We've gone from 30 million to almost 60 million in dividend. They're doing something right. If it's not broke, don't fix it. And I mean, every single year we get more kids that want scholarships, and the dividend is there to take care of it. We have not asked anybody to make that tough decision that, are we going to not do the scholarships and take it away from human services, or not do this or not do that? And the truth is, by law, C&B only has to give this council 35%, 37%. But it's been running 70%, folks. That $100 million that they put into health care was above and beyond the dividend. They have come to us time and time again. The new clinic where the mold is over at Mankiller is going to be a gift from them, above and beyond the dividend. It's not reducing the dividend. It's above and beyond. It's out of their portion for jobs growth.
And excuse me, now I have to give credit where credit's due, and I do sometimes. You and I have spoken.
Absolutely.
You know, and I'm not saying anything. It's the bigger picture that I've always felt that, you know, we're doing great, we're doing great, we're doing great. But does that constitute this council not having a voice in it? And I don't think so. I mean, we're doing great, and just to notify us, there might be a time where we feel we don't want something, and without some kind of writing on paper, essentially we can't do anything about it. But don't mistake.
Yeah.
No, I recognize and give credit where credit is due. But that's my big picture, and I think I still had the floor, but I'm going to say thank you and please continue.
Sure. You know, there are some tribes, I've had a chance to work with many of the tribes in Oklahoma. Some tribes, the council takes all of the dividend, then they give it back to the business. And those people are in a world of hurt financially. They're constantly in turmoil about not having enough money for scholarships, housing, and so forth. If we were in that predicament, if we were short on scholarship money, and we weren't, as a council, not getting any funds for rehab and do small projects, yes, I would be the first one to say, Chief, not just no, but hell no. But you guys are performing. I'd just like to have that board of directors have a little bit more say-so up there. The chairman, know who he is, and they just need to be consulted. That's all I say, because we are doing well right now, and we have to take advantage of that. You guys are doing a good job, or I wouldn't be supporting it.
Sure.
Yes, Councilor Walkenstead.
Chief Baker, you know, this legislation isn't directed at you. It's directed at the future of Cherokee Nation. So your character is, you're going to poll everybody, and if it's successful, you're going to move forward, and if it's not, you're not going to move forward. But who's to say the next chief down the road has the same character attributes as you do in conscience?
I trust the Cherokee people will do that.
And you know that there's going to be, you said you didn't want to, you want to make sure the new council is able to have this type of legislation for their support. The new council will come in and they'll be well prepared as well, just like you were and we were. You have to give them credit too. I don't want to infringe on somebody else's decision making a year from now. Let them come in and make decisions. That's legislatively. That's.
I wish that this would have passed back in 2005, back in the Smith administration.
We weren't around, so they took care of it their way, and we'll take care of it our way.
But if this would have passed, we wouldn't be here today, and there'd be more lobbying efforts take place to the council members, say, hey, we're gonna give this much, or negotiate how much money to give towards political.
Each council group can always do that. I mean, they have the authority to make legislation. Right now, it's working though. Yes, Councilor Lake, let's wrap this up.
I will, and two things. One, I think that entire board needs to vote on that issue, on these issues, the business board.
Yes.
The other thing is, I was informed about this decision. I wasn't polled, I wasn't asked for a vote. I vote here in this room, and I vote in the council chambers. I don't vote on the telephone, and I don't vote in a private meeting. I vote here. That's where I vote. And the insinuation that I agreed or authored or did anything to say that somebody.
I said that there 15 said yes. One said no, and one said they wanted to think about it.
Okay.
And you know which one you were.
Yes, sir. Well, I want to make that clear. And again, I don't vote on the telephone. I vote in here. And I was pressed for a vote down the hall in a private office one time, and I didn't do it. That's because the CMB board should have voted on this, and then would all say, oh, you know, those guys, and I forget how many there are, men and women, but they approved it. So when you call me and notify me that something like this is happening, and it doesn't matter what it is, it could be these donations that you're talking about here or something else. All I know is that I'm getting notified. I'm not getting a chance to voice my opinion. I'm not getting a chance to discuss it in this transparent committee. I'm not getting a chance to vote on it. Thank you.
Okay. Everybody good? Councilor Buzzer.
Well, what I got to say about this is, I know, Speaker, you had said that you'd like to see the CNN board to vote. Heard from Councilor Lake. Now, who's going to make them do that? Who have any control over what they vote or not vote on? I mean, we could sit here all day and say we'd like to see them vote, but what if they decide they don't want to vote? You have any say about that?
Just report to us on how the voting went next time. Keep us informed. Okay? All right, Councilor Taylor, do you have a comment? Let's wrap this up.
I just have one comment, and I will be brief. Yesterday in our resource committee meeting, Sarah Hill said, when I go to the state capitol with an issue, I get a meeting because I represent the Cherokee Nation. That indicates to me that our inroads, whatever we're doing politically, is getting us a seat at the table when we need a seat at the table. That's all I have to say about it.
I think we get a seat at the table even if we're in Washington, D.C., correct? So, anyway. Okay, in closing, we've made all the announcements last night. We won't drag this on. Chairmen of committees, do your homework, do your due diligence, consult, communicate with the executive directors, and we will run this like it's supposed to be run, like a government. 15 minutes. I always make sure my meetings run on time. I don't run on Indian time. You know, if my meeting starts at 10, I'll start it on 10. I've given you 15 minutes here, so I need to entertain a motion to adjourn. What are we voting for? Okay, all in favor, signify by saying aye.
Aye.
All opposed?
Aye.
Okay.
I'm just loud. Roll call. You do roll call, Speaker. I'm just loud.
I just heard 3 yes.
I think you roll call.
Okay.
We need
Roll
to take
call
your
vote.
Brian Warner,
No.
Bill England,
No.
Keith Austin,
No.
Early Buzzard,
Yes.
Joe Byrd,
No.
Sean Crittenden,
Yes.
Mike Dobbins,
No.
Frankie Hargis,
No.
Wanda Hatfield,
No.
Rex Jordan,
No.
Dick Legg,
Yes.
Mike Shambaugh,
No.
Mary Bakershaw,
No.
Leo Smith,
No.
Janice Taylor,
No.
Victoria Vasquez,
No.
David Wackenstick.
Yes.
We have 4 yes and 13 no.
Okay. Entertain a motion to adjourn. Second. We're adjourned.